occurs, you must notify that employee within 7 days. Okay? 7 days you have.
Employee. They keep copy of it, correct? In their file?
Yeah.
This is
Yes.
the employee,
Yes.
you keep copy of it.
Yes, you would keep a copy. You definitely want to keep a copy in their file. I highly recommend that. They sign it, you keep a copy in the file, you give a copy to the employee.
So
Regardless
do you
of
make sure it gets signed?
Regardless.
only one employee, two employees.
Doesn't matter.
Okay.
Doesn't
All
matter.
sides.
They don't, it doesn't, regardless of the size of the employee. If you have one employee, you have to comply. Yes,
Does it
ma'am.
matter who has the original?
I usually, to be honest with you, as an employer, I would keep the original and give a copy to the employee. That's just something as an HR professional, and I always keep the originals of everything and give them a copy. Okay, so the notice to the employee may be a new notice, a notice of only the changes. So like you don't have to put all the information. If the only workers' comp change, then you would just give the workers' comp information. And again, you're going to want to keep a copy of that. The law does not require that we keep a copy, but as you all know, that's your only defense, that you actually gave the copy to the employee, so definitely keep a copy in the employee's personnel file. Senate Bill 459 talks about misclassifications of independent contractors. This is another huge issue that we see every day as it relates to misclassification. We've got our exempt, non-exempt, hourly or salary, if you want to call it. We've got enough time, Scott, we're good. This is another big one. This creates penalties for willful misclassification of workers as independent contractors. And I will go back to, I don't care if the person says they want to be an independent contractor. I'll give you a real life story. I had a client of mine call me and say, hey, you know what, I've got this employee, they're retiring, and they're moving to Missouri, and they want to continue to work remotely, so we're going to let them move remotely, and they're only going to work part-time, and we're going to classify them as an independent contractor, but they're doing the same exact work that they were doing while they were here.
No.
What do you think? No, you cannot do that. Yeah, but they're not working here, and they're going to be, it doesn't matter. Well, I've got this person, and you know what, I just want to try them out for a couple months and see if they're going to work out, so I want to 1099 them. No, we cannot use that as a trial period. If you would normally employ that person as a W-2 employee, that's a regular position. It doesn't matter. California is an at-will state, so we can terminate anybody at any time for any reason. They can leave at any time for any reason. That is not necessary. Much like introduction periods, there's no such thing in California. It doesn't matter. Once they're your employee, they're your employee. The difference is that now they're imposing a fine of from $5,000 to $15,000 for a violation, and that fine goes up from $10,000 to $25,000 if it is a pattern and a practice. So if they can prove that you routinely and regularly misclassify, it's willful, and that fine goes up. Okay, and there's also joint liability for any person who knowingly advises an employer to treat an individual as an independent contractor to avoid employee status for that individual. And that excludes your attorneys, but that would be someone like if you have a consultant that tells you, oh yeah, sure, go ahead. There's a joint liability. Yes, sir. That would be me.
So case where the retiree moved out of state, are they subject to California deductions, wages, state income?
That's a great question, and that's kind of a little bit off subject, but I get that question a lot when we're starting to talk about whether or not we have to pay wages. So if you're a California-based employer, but you have employees working in a different state, which state presides over who pays tax to what? And in California, it's if they are doing work for 6 months or more, I believe, then you have to pay California even if they are living in a different state. So like we have people that work in Nevada but live in California. It's usually where the employee resides, but California says, well, it doesn't matter if they reside somewhere else. If they're doing work here for a length of time of 6 months or more, you have to pay California taxes for that employee. But in that case, it would be whatever state that they're working in. And that becomes an issue with employers because then that means you have to set up another account for unemployment insurance, and that's something that your payroll company
and they would have to file a California income tax return. They would have to file a California income tax return from Missouri or wherever too.
Right. Yeah. If they were working in California. Now, if they're working in Missouri but they're California based, then you would pay Missouri payroll taxes. But that becomes an issue for the employer because now you have to set up an account in Missouri. You see what I'm saying?
Mm-hmm.
For any unemployment or disability or whatever they might have there that's mandated by the state. Yes, sir.
Does this apply to nonprofits?
Yes, it does. Yes, it does. Any other, yes, ma'am?
What if the states have a reciprocal agreement? Is that still?
Well, then if you,
Is that excluded?
yeah, that would be excluded, yes. Okay, so we do have a handout on a program to correct misclassifications. Again, this is one of those things that I highly encourage you, if you haven't taken a look at, or you have a lot of independent contractors, make sure that they are truly classified correctly. Not only are there penalties assessed, but you then would be responsible for the payroll taxes of that employee and the employer's portion. The employee is not responsible for those taxes. Okay, you would be. So any payroll taxes that they should have paid during that misclassification period, you are now liable and responsible for as the employer. Okay, so again, there's a handout there for you. If you have any further questions about that, we are going to stay after the program.
Like
to answer those
comment. This is a federal issue. The IRS is actually stepping up enforcement of 1099s, and they're auditing, blindly auditing 1099s. So please do go through and verify and make sure that they are actually 1099s.
That's what we're saying. You're definitely going to want to conduct an audit. I would suggest, if anything, out of what we talked about today, the Wage Theft Protecting Act, make sure you get those forms out to your employees, a audit on your independent contractors, and an audit on your exempt employees. 3 things, if you don't take anything else away, 3 things that are very, very important that cost you a lot of money as an employer. AB 1236, this is the electronic employment verification. Neither the state nor any city, county, or special district may require the use of E-Verify by an employer. It does not prohibit E-Verify, but it's saying that no one can require the use of E-Verify. Okay, if you want more information, yeah, that is good news. If you want more information about this, you can go to their website. And the only caveat to that is unless it's required by federal law or as a condition of receiving federal funds. There have been some changes to the pregnancy leave law here in California. Good old Governor Brown has decided to also to protect pregnant women and new mothers, and he has mandated that not only do we have to ensure maternity services are covered under our health insurance plans, new mothers can no longer use health insurance when taking maternity leave. And also, not only that, it makes it illegal for an employer to refuse to maintain and pay. So it's now illegal to refuse to maintain and pay for coverage for an employee enrolled in a group health plan who takes pregnancy disability leave. And before, it was only covered for 3 months under FMLA, and then you can put them on COBRA. Now you have to guarantee that health care coverage for 4 months. So that's a huge change. If you were stopping the coverage after 3 months and they were out for the full 4 months under PDL, you have to continue and maintain that coverage for the 4 months. Okay, you can't cut it off and go to COBRA after 3 as you were able to do in the past. So that's brand new. Okay, you'll need to revise your handbook policies as it relates to your leave of absence. Keep in mind, pregnancy disability leave is if you have 5 or more employees. If you employed 5 or more, you have to comply with PDL. FMLA, CFRA, as you know, it's 50 or more employees, 5 or more.
That means that during those 4 months, you're actually paying the premium that you paid prior while they were working. That you don't have to tell that person they have to pay the premium while they're on
Well, you
unpaid
can you can request that they pay the premium, but it goes back to what I was saying earlier, which is you can't terminate the coverage if they